Good morning and welcome to HR Advance and our end-of-year webinar on 2017, what happened and what's ahead for 2018. I'm Alison Williams, Managing Editor at HR Advance. It's my job to keep you up to date with the latest information affecting your workplace, and to that end, I'm the one who sends you regular newsletters with news and information from our Knowledge Centre. Or you can log on directly to HR Advance and click on the Knowledge Centre from the homepage to browse the latest articles. With me today are our speakers. Firstly, Lewis Izzo, who is a specialist employment and industrial relations lawyer and director of Australian Business Lawyers and Advisors, the team behind HR Advance. Lewis acts for a broad range of employers across both the private and public sector and has extensive advocacy experience in state and federal courts and tribunals. He was one of the lead employer advocates in the 2014-2015 Fair Work Commission annual leave test case, as well as the highly publicised 2016-2017 penalty rates test case. Following heavily contested hearings in both proceedings, Lewis ultimately succeeded in securing a raft of amendments to modern awards in respect of both annual leave and weekend penalty rates. Now, also with me today is Fiona Corbett, who is the National Manager of the Workplace Advice Line with Australian Business Lawyers and Advisors. Fiona has worked as an industrial relations advisor for the federal government and also the New South Wales Business Chamber. She combines significant business experience with from owning and operating a successful family business for over 20 years, with a number of years of HR management experience gained in Sydney law firms. Now, I'll just take the opportunity to give the Workplace Advice Line a plug. Don't forget that premium subscribers to HR Advance get 5 free calls to the advice line every year. They're available to you 24/7 to answer your workplace queries. So if you are feeling a little out of your depth, you can give them a call and their expert advisors will help you out. So today's webinar is our opportunity to go back over 2017 and remind ourselves of the employment relations milestones. Fiona is going to draw together the key issues which are concerning employers throughout the year and provide some suggested solutions. We'll be looking at some important developments throughout 2017, both legislative and arising from tribunal decisions and other sources. And then we'll look over the horizon and see where those important developments are likely to be taking us in 2018. And we hope to have enough time to answer some of your questions you submitted beforehand. So I will get started by putting a question first to Fiona. The Workplace Advice Line takes literally tens of thousands of calls every year, so I'd like to hear about what was concerning employers this year.
So first of all, I'll talk about termination. So continued concern about claims, unfair dismissal claims and also general protection claims, concerns about the disciplinary process and the complication of going through that process, and which means that the result of that, of not following a process, a good process, is keeping on poorly behaved or poorly performing employees.
So that's, Fiona, I take it termination of employment is, where does that sit in terms of the ranking of the frequency of calls? Is it up there in the top 10? Or?
Oh, absolutely in the top 10, always, right. Yeah.
Okay.
It's probably about a second or third from the top.
Right, okay. Yeah. And I suppose one of the interesting things that arises with respect to that is that when you look at termination of employment, there's something that we tend to see employers struggling with, which is that they often can tend to fall in the trap of managing their business out of fear of industrial regulation and out of fear of unfair dismissal claims. In our view, the reality is that, yes, you need a level of knowledge and a level of awareness about unfair dismissal laws. You need a level of knowledge and awareness about the regulatory system and discrimination laws and things like that. But you shouldn't be operating, particularly when it comes to unfair dismissals, in fear of the fact that these laws exist. I mean,
yeah, that's right.
We see about 15,000 unfair dismissal claims filed a year, but of those 15,000, only about 20 end up in reinstatement orders where someone's actually put back into the workplace. So the reality is that in a large number of cases, these matters are settled at the conciliation stage. Often the settlements could be for some nominal amounts, whether it's 4 weeks, 6 weeks pay, something like that. Where it's not settled, sometimes there are hearings, and sometimes you'll see employees either succeed and get compensation orders or not succeed. But the reality is that it is very rare in this day and age still to see employers terminate someone and find that person reinstated to their business later on down the track. And I think for employers, the message is that doesn't mean you can just launch about with gay abandon kind of firing at will. That's not what we're saying. But I think equally, if you have a valid reason as to why someone's not working out, if you've gone through a legitimate process to try and, if it's performance-based, give them an opportunity to improve, or if it's conduct-based, hear their side of the story. And at the end of that process, if you're still not satisfied that they're able to perform the role, they're able to continue in the role, then really you can move to a dismissal. And it's more about ensuring you have a valid reason and an appropriate process. What we don't want HR managers in particular thinking is that there's no ability to kind of improve their overall business when there are circumstances in place where someone's really not a genuine fit. And I think that's one of the other things about where the probationary period fits into place with all of this. The probationary period is there to enable employers to assess employees over an initial period of about 6 months for bigger employers, or if you're a small business employer, 12 months. And that is really your free opportunity to look at someone, see how they're operating, see how they're working in your business. And if it isn't working out, you have the ability to terminate. So long as you're not doing it because of reasons prohibited by discrimination legislation, so race, sex, political opinion, age, the list of prohibited protected grounds, as long as it's not one of those grounds protected by discrimination legislation, use your probationary period and you have an ability to terminate at the end of it. So I think it's interesting that it continually comes up. I hope that's because people want to improve their process, but we certainly don't want people operating in a world of fear. It's not that hairy an industrial system. The Commission does recognise that where there's a valid reason why someone isn't working out, that an employer should have the ability to move people on.
Yeah. And we'll certainly take people right through that process. So from when the issue's identified to the first formal written warning and second formal written warning, and then moving to termination if required. And of course, there's a number of cases where we wouldn't even be suggesting a formal written warning. If it's serious misconduct, we'd be suggesting that they move straight to termination.
It's interesting you mentioned the warnings. We often hear from people talk about this kind of magic rule of 3 written warnings. I mean, what's the Workplace Advice Union standard position on, with respect to warnings? 2.
But we also say that in the first, so particularly for a longer term employee, so someone that's well and truly out of their probation or minimum employment period, that first of all, you say to someone, there are issues and we're going to be addressing those issues. So it's not, in fact, a warning, but it's just a warning that there's going to be warnings if behaviour doesn't improve. So it's setting out what the expectations are for the role. And then after that, you set up a time frame. So it might, depending on what it is, if it's someone just not meeting their sales KPIs, they might need another couple of months before you actually move to the first warning stage, then set up another time frame to issue the second warning if required.
Yeah, and I think this is the interesting thing, is there is no magic rule. It's just what's reasonable in the circumstances to give someone an opportunity to improve their performance. Yeah. So if you just tell them they're not performing one day and just terminate them, of course that's going to have an element of unfairness about it. But if they've been given a warning and then they're given a final warning and they're still not improving, despite being given a fair opportunity to turn things around, that's when you say, well, we have had a decent notification and warning process. So people shouldn't get married to the numbers so much as ensuring there is a at least clear notification there's an issue, opportunity to improve, giving them the awareness that things don't improve, disciplinary consequences can follow. And as you say, with behavioural things, it might be the first time they do something, they're out, depending on the seriousness of what's occurred.
Yeah, that's right.
Sure. Well, yeah, that's I suppose that's termination. I noticed glaringly on the list the next one's personal leave. I take it that's very high on the list.
Yeah, again, that's in the top 5 call types that we take. So what we've noticed as a team is that in the last 12 months, we're getting lots of questions on mental health issues. And that's very difficult for employers to deal with, and employees, of course. So what we find is that, generally speaking, the employers really want to do the right thing by their employees. They want to make it right, and they're prepared to work with their employees. So some of the suggestions that we come up with is, if it's a larger organisation, that the employee be suggested to go to their employee assistance program if they have one. There's also other organisations that are really good and useful, such as Beyond Blue and Heads Up. So another idea may be to provide some flexibility with hours, the type of work, if that's available, and just have a chat with the employee generally to see if there's any assistance or support that can be provided to try to keep them in the workplace and ensure that their performance is satisfactory.
Yeah, so one of those things with mental health is really, there's kind of a few steps in the process, isn't there? The first is, how do you support this person? And all those things you've talked about are ways in which to try and help support them to deal with whatever the issues are. Now, sometimes when these mental health issues arise, then other complications arise. So, for instance, it could be that the mental health issues contribute to someone's incapability of dealing with other people in the workplace or with their managers, particularly where there's anxiety, adjustment disorders, where there's a level of paranoia about what management are doing or intending on doing. And that's where it gets a bit trickier, because on the one hand, you're trying to support, but on the other hand, you're actually trying to keep them working within the business in a productive way. And so I think that's where it does get a bit trickier, and you need to start saying things like, well, how do I, firstly, so I've supported, the next thing is, how do I accommodate? So there are things I can do to accommodate. Is it about putting in place a different reporting process? Is it about seeing if I can arrange for mediation between the people that are having difficulties in getting along? Are there other things that will help accommodate? And one of the things you mentioned was flexibility with hours. It might be that they just can't handle the full-time load the way they're currently feeling. And so I think in terms of the order, it's support, accommodate. Now, then if that is exhausted and that's not working, that's when you're then having a much more significant discussion about, well, how is it that they're actually performing the role? Are they able to perform the role? And that's when a whole other layer of things come in. And that's when, if they're not performing, are we going to have a discussion about that, but conscious of the fact that they need extra levels of accommodation, as I say, but even having given them, are there performance discussions that need to be had? Or is it that they are simply incapable at the moment of performing the role? And if that is the case, and I think we're going to talk about this in a bit more detail shortly, but if that is the case, you need to have a very good understanding of what the role is and what the inherent or core requirements of that role are, and whether they can or can't do it. Because the moment you start taking disciplinary steps against an employee, if the reason that they are struggling is because of their mental health condition, you're going to look at discrimination, liability, or exposure, because they will say, well, I'm being treated in a manner that is disadvantageous to me because of my mental health condition. And so in order to get around those discrimination laws, or not, I withdraw that, not really get around, but in order to be able to implement a legitimate process, it's important that you can rely on the exemption to the discrimination laws, which is that an employee can, for instance, be removed from their position or have certain steps taken that might be disadvantageous to them if it's been done because the inherent requirements of the position can no longer be performed by that person. And so you really need to start saying, well, what are the requirements of the role? Getting good medical evidence about what is the nature of their health condition. You can't just make your own Dr. Google assessment of what it is they're suffering from. You need to have very clear understanding from a medically certified opinion and a report telling you what they can do, what they can't do, what the nature of the condition is, and then use that to actually then form an understanding of whether they can or can't perform the role. And unless you've done that, if you're going to start taking steps to exit someone based on their condition, you're going to end up in a fair amount of strife.
Trouble, yeah, that's right.
So I think that's a big one. I see there's a couple of other subcategories in terms of the personal leave.
Yeah.
Wondering if you could take us through the second one. What type of queries you're getting come up?
So with this injuries outside of work, we're clearly not talking about any kind of workers' comp. So injuries that have been occasioned within the workplace. So lots of questions around this, and oftentimes the employee is pushing to return to work before they're fully fit. And so our advice with that sort of question is that for a non-work related injury, they're under no obligation to have the employee return unless they have something that they can get them to do. So if they've got another role that they can perform, so perhaps if it's a person who ordinarily works in a store room, so picking and packing, if that person is able to do some clerical work, and if there is some clerical work available, then perhaps the person could come in and do that work for a period of time. But the employer is not obliged to do so. A lot of time they're getting pushed. The employer is getting pushed by the employee because they need the money. So they're out of personal leave. They don't have any other entitlements they can use. And they're saying, I really need to come back to work. Sometimes they even produce medical certificates that state they are fit to return to work, which really have to be taken on their face value. But on a number of occasions, the employers push back and say that they would like the employee to see their own doctor so that they can be sure that they are actually fit to perform their duties.
And I think this really, it is going to depend on the nature of your industry. If you have an employee who's off sick for a day and you work in an office-based environment, the notion that they come back and say, yes, I'm fit, and you're saying, well, off to an independent medical you go, that's not likely to be a reasonable direction.
Yeah.
But you happen to be working in food manufacturing or processing, and you're someone who's off sick for a day and comes back magically the next day, maybe it is reasonable in that circumstance to say, well, no, we need to be absolutely sure because of the highly sensitive nature of the work we're involved in. And that can be the same for persons dealing with health and aged care, perhaps, or when we start to move then into the safety critical industries like mining, manufacturing, where there's construction, where there's significant health and safety risks. If you have someone who has had a physical injury, it might be that you don't want them returning to. You're absolutely certain that that they have are not at a higher risk of exacerbating that type of injury. So directing people to medicals, it's an interesting one. Employers need to be very conscious that you have an implied right to issue lawful and reasonable directions. And as part of that, you do have the right to direct people to be medically assessed and direct them to give their consent, to give have the medical report handed over to you to see if they can safely do the role. But you only have that right if the direction is reasonable. And so what's going to be critical is looking at the context leading up. How long's the person been off work? Why is it that you require a medical report now and didn't previously? And so the types of circumstances where we do think that it's justified is where someone's had a long-term absence and you need certainty about their return. Where someone's in a safety critical role and you need to have an understanding that they can do the role. Another example, which is quite a sensitive topic, might be people who become pregnant. I mean, in some roles, it's entirely normal. It's a very normal thing to happen, and it happens across the board, all across the country. But in some roles, whether it's certain roles that might require a particular level of physical exercise, whether it's policing, whether it's something like that, there might be a point at which the organisation says, well, we need specialist medical advice to tell us it's okay for you to stay in this role because it might be that the job's no longer safe for you. And it's the same for any type of development relating to someone's body. So you just need to be satisfied that you have a legitimate basis to be going out and sending them off. And if you do that, you can direct them either to get an opinion from their own treating doctor or you might want your own independent medical expert.
So what's the next one, Fiona? We're moving quickly, I think, onto the medical evidence.
Okay, so still around personal leave, we get asked often, what is the employer required to accept? And our response to that is evidence that would satisfy a reasonable person. So this year we've been asked about pharmacy certificates and whether they need to accept that. We've been asked about online doctors, so people can actually pay a fee, something like $25 or $35, to speak to a doctor. They actually do speak to them either on the phone or by Skype or some other form, and they're then issued with a medical certificate. So what we would say with those kind of questions is it's probably okay, it's probably reasonable for a short absence. So a day or two, maybe 3 days, that they may well accept that evidence. But if someone's been off for weeks or a month for some extended absence, like Lewis was talking about, is a pharmacy certificate acceptable? Probably not. And they can probably just say that's not reasonable. They require further evidence.
And so the interesting part of this is, and what people need to remember is that what the Fair Work Act requires is that whenever anyone takes personal leave, you need evidence that would satisfy a reasonable person about the need to take the leave. So that is the test. The Fair Work Act does not prescribe any particular test of what's reasonable. It just says you need evidence that would satisfy a reasonable person of the need to take the leave. Now, the two clearest examples of that would be a medical certificate from a doctor, or if that's not available, perhaps a stat dec. And they're listed as examples in the Fair Work Act. And as you said before, Fiona, yes, you generally take a medical certificate at face value, but there might be some circumstances where you don't. And for instance, I certainly have had scenarios where an employer's had good reason to not believe a medical certificate for particular reasons that they've outlined. And so we've required more than that. And so, I mean, pharmacy certificates are starting to really open the can of worms at the moment. But as a business, you can start to push back. I mean, generally medical certificates is still the go-to standard.
Yes.
I think for most employees that are good employees, it's not really going to be an issue. It's the employees that are becoming problematic, that are taking long periods of leave for reasons that appear to be not legitimate. And those employees, you might find they're getting medical certificates anyway. You might find that they're going to a medical centre one day, they go to a different medical centre the next day. The medical certificates always say unfit due to medical condition. They don't actually say what it is.
Anything.
And so they're medical certificates, but are they satisfying a reasonable person? Well, maybe towards the end of it, they're not. And so what you might need to start doing is issuing directions saying, well, what we actually require from you is a medical certificate that's set from the same centre or one of a number of specified centres that sets out the nature of the condition, when the prognosis is for return, etc. Because of the history between the parties, just the vanilla medical certificate is not satisfying anyone anymore. So even a medical certificate can be looked through after a period of time. So just remember that the underlying test is what would satisfy a reasonable person. And I think that's the key issue with that one. And
that's interesting, Lewis. I hadn't heard that before, that you could actually be more directive. And, I think I'd probably put myself in the fearful category there, like, it's a medical certificate, hands off.
And that's not the. I mean, generally that will be the case, particularly for an isolated. That will be the case for an isolated instance of illness. But in relation to problematic employees, and they're the ones where we really see the issues.
Long-term absences.
That's where we start to require more from them, and where there can be a legitimate basis to do so.
Yeah. That's it.
Interesting, very interesting, in fact. What about the last on your list there, Fiona, award coverage? What are people asking, or have they been asking this year about that?
Well, award coverage, interestingly, is something that we still discuss every day. And so considering that the modern award system has been in now for 8 years, we just find that for so many businesses, and we're not talking about just new businesses, for so many businesses to still not know which awards cover their business and their employees is it just shows the complexity of the system, that it's a difficult system. When we establish award coverage, it's still difficult even for us to work out what the award's trying to say. So we're interpreting awards, different clauses of awards, after we've worked out coverage, just all the time.
Okay.
Yeah.
So what's the process you go through to actually determine award coverage, Fiona?
Yeah.
Take us through the life cycle of an issue.
We'll often get asked about who is award free, because people have the understanding that everyone is covered by an award. And so that one will say, well, generally speaking, you've got these people that are award free, and there's always exclusions to just about everything that we ever say. But you've got HR people, marketing people, PR, those types of roles, accountants, lawyers, they're all award-free roles. When it comes to award coverage, we talk about the industry, what industry is the business in, and then what the occupation is. So if we work out there's an industry award, we'll have a look at the we'll have a look at the classifications to see if there's anywhere that we can fit the employees into the classifications of that industry or occupational award.
What about managerial employees?
Award free, generally speaking, award free.
And you just need to be careful with that, because some of the awards do have quite classifications that go quite high up, and you can have supervisors and things like that.
Yeah.
But a general manager of a particular business, etc.
Yeah. Financial, chief financial officers, those sorts of roles are going to be award free. But there are some awards. So banking, finance, insurance award, and also the social community award have really quite high level managerial positions covered. So they're the kind of exclusions that we look at. But if we're talking to someone who's in the social community industry, we know that. We know that those people, that a whole lot of their managers are likely to be covered. And the same with the banking finance award.
Sure. All right. Well, I think so. That were the three key areas that were coming through the WAU. I was then going to talk about some significant developments we've seen over 2017, and this is really just the big ticket items that have transpired in the last 12 months. One of them happens to be from last Friday. So hot off the press, so to speak. We had a decision from the Fair Work Commission last Friday in Kiam and Navitas English Pty Limited, which involved an employee, Mr. Kiam, who was employed by Navitas on a series of what we call maximum term contracts. Now, I might just take everyone through what we mean when we talk about a maximum term contract. A maximum term contract is effectively a contract for a period of time. Might be 6 months, 12 months, a year, or for a season, or even for the completion of a project or a task, but which has within it an ability for the parties to terminate the contract early. So that's why we call it maximum term, or often outer limits contract, because it sets the outside bounds of how long the contract will go for, but has an ability to terminate earlier. And when people talk about engaging people on a fixed term basis, often what they mean is they've got a maximum term contract, because most fixed term contracts that we see still have this ability to terminate early. And the state of the law has been for the last decade that if you have a maximum term contract expire at the end of its life, that's not a termination by the employer. That's just the expiry of the contract. And what they used to say is that that's the contract ending by a fluxion of time, is how the commission used to talk about it. Now, what that meant, importantly, was that if a contract ended like that, you wouldn't be subject to redundancy liability, because you as the employer are not terminating the employment. You're just the employment's just ending by mutual agreement. It's ending according to the terms of the contract, and also you wouldn't be subject to an unfair dismissal claim, again because you haven't terminated the contract. You might have decided not to renew it, but it's ended by virtue of its own terms. And that was the state of the law in quite a settled fashion for about a decade. Last Friday, a full bench of the Fair Work Commission handed down a decision which turns all of this on its head. The Commission cast a lot of doubt over a number of arrangements where employers might be engaging employees on successive maximum term contracts, it really started to say, well, just because a contract elapses or expires and the parties don't renew it, that doesn't mean that the employment hasn't been terminated at the initiative of the employer. There could be still some moving act on the part of the employer that has brought the relationship to an end, which really does change the approach. The Commission was saying that there might be any number of reasons, things the employer's said to the employee, things the employer's done. There might be an expectation that the relationship's going to continue. And if the employer's decided it's not going to continue, even though the employee wants it to continue, then the employer can't just clean their hands of the situation and say, oh, well, it's the contract expiring or ending by a fraction of time. So what the Commission has said is, you cannot just assume that because the maximum term contract is going to end, you're exempt from unfair dismissal claims, you don't have to pay redundancy if you're not continuing the position. They've said what you need to look at is, was there a genuine agreement in place before the arrangement was entered into between the parties that they both genuinely agreed that the employment relationship would end on a particular date? And if there was a genuine agreement of that nature, are we sure there was no pressure put on the employee? Are we sure there was no representations made that gave rise to any expectations? Are we sure the employer hasn't done or said anything to change that state of affairs? If anything has happened in the intervening period to change that state of affairs, you could be in trouble. If there was some unfair pressure placed on the employee, you could be in trouble. If there's representations that have been made that make it unclear whether the parties expected the relationship to end, you could be in trouble. So the Commission's looking at anything that might arise that changes the nature of this genuine agreement. If you have a genuine agreement, the relationship would end at a particular date and everyone's acted it consistently with that genuine agreement, then yes, you're probably still exempt from unfair dismissal laws and redundancy liability, but you need to be conscious, and there's a number of steps the Commission has set out in this decision that need to be looked at. You need to be conscious that there may be a number of traps that mean that your maximum term contract can no longer be relied upon as bringing the relationship to an end automatically. Now, our firm has published a circular on this that went out on Friday. It's gone out to all our clients. I understand the New South Wales Business Chamber will be sending out a circular on this in the next few days. That'll probably go to most of the listeners on this webinar. And it goes into a bit more detail on the topic than what I've been saying. But it's certainly an area to watch. If you're engaging people max term contracts, this could well affect you. And you can't just assume that they will naturally end according to their terms. It could be seen as a termination by the employer. So that's certainly a space to watch. The next area, which is really a hot topic and has seen considerable movement in the last few years, but particularly 2017, is enterprise bargaining. And there's two developments on this front. One is we've seen a consistently higher trend in parties terminating enterprise agreements. And primarily by that, I'm referring to employers who are no longer satisfied with the EA arrangements and want to go back onto the award safety net. And that's been met with significant resistance by the union movement. The unions have a view that the award safety net is not an acceptable safety net, it's too low, and that the EA safety net is a better one and a more appropriate one. And so there's considerable tension in this space. Employers are continuing to move to terminate EAs and go back onto the awards. Unions are ramping up a public advocacy campaign to try and make this more difficult in future. And I suspect this will be part of the Labor Party's platform moving into the next federal election. And we're going to talk about that more in the next slide. Of more importance is that there's a huge and much higher focus on the boot. We've seen some very large employers, namely Coles, most of all, had their EAs picked apart by employees who were able to demonstrate that the EA did not provide a safety net that was better off than the modern award. The first Coles agreement that was torn apart was early this year. The Commission terminated it and it meant that 75,000 employees ended up going back onto an older EA because the Commission was not satisfied that the existing Coles EA was better than the underlying award. The next EA, the predecessor, was also subject to an application by another employee who'd said that she was worse off under the EA than under the award. And what this has done is it's really signalled that the Commission is putting far greater focus on is every individual employee subject to an EA better off under your EA than under the award. If one employee is not better off, your agreement will fail. And the Commission is starting to look more and more at every term and more at every permutation and combination of rosters and shifts that might be put to an employee in order to see whether they're better off or not. Now, this has had some ramifications. We've seen bargaining in the retail space stall considerably as retail employers struggle to work out how it is that they're meant to bargain and get an EA over the line. There's huge levels of scrutiny on loaded rates in particular. So this is where EAs, where rather than having separately identifiable base rates of pay, allowances, penalty rates, you have an all-up loaded rate. They're quite attractive to employers because they provide certainty of expenses and cash flow, but they're quite unattractive to the Commission, and they're under huge scrutiny at the moment. There is a case before a full bench of the Commission that's looking at 5 employer EAs together, and the Commission will likely hand down as part of that case some principles on how the boot is meant to be applied. But there's going to be a huge degree of focus on that front, and that's going to continue. Just moving through the rest of the developments, people may have heard a lot about the vulnerable workers legislation. What that's all about is that there's essentially new legislation that has come to pass that predominantly affects franchisors and holding companies. So if we start with franchisors, what it says is that if you're a franchisor, you're not only liable for your conduct, but if you knew or reasonably ought to have been aware of underpayments or improper employment practices in your franchisee businesses that are run by franchisees, you can be liable for what they have done. And so the message for franchisors is to very much ensure that they're taking appropriate steps to do their due diligence and ensure that the operations of their franchisee businesses are above board. And this has all obviously come from the 7-Eleven debacle of a couple of years ago, where it became pretty apparent pretty quickly that a number of 7-Eleven franchisees were not engaging in compliant employment practices. And this is designed to make sure that the ultimate franchisor is responsible. The same applies for holding companies. Very same thing. If you have subsidiary companies, you're likely to be held liable for their practices if you knew or reasonably ought to have known that they were engaging in inappropriate or non-compliant employment practices. So that the vulnerable workers legislation has pretty significant and hefty fines attached to it. You really need to be on this if you're a franchisor or a parent company. Simultaneously, and kind of in parallel with this, is the Fair Work Ombudsman's increased focus on accessorial liability. So the FWO is very much interested not just in bad employers, what's an employer done that wasn't appropriate, but they're looking at what was the level of involvement of individuals, of HR managers, of directors in the underpayments or the breaches. And they're often looking to add as accessories to any underpayment claim the actual conduct of individuals. And more than that, they're also going for businesses in the supply chain. So if you're a business that's tendered out work to a different business, a legitimate contracting arrangement, the FWO's view is if you knew or ought to have known that the rates that were being paid, because the rates for the work are so low that they can't possibly be compliant, you can be on the hook as someone who's tendered out work as an accessory. And the FWO did that a lot with the trolley collectors at both Coles and Woolies. It went and it saw that the trolley collection services weren't legitimate, weren't above board, but it had no interest in going after the trolley collection companies. It went to Coles and Woolies and said, you've engaged these companies to perform these services. You must have known that the services weren't appropriate. the rates were too low to be legitimate. You're the big whale we're interested in. And as a result of that, both Coles and Woolies have brought their trolley collection services in-house because they've realised there's no value in outsourcing it. So, again, you're someone who's using outsourced labour. For instance, are you using outsourced security services? Are you using outsourced cleaning services? If you are, if you know there's something fishy about those rates, it could be you that the FWO comes knocking on your door. So that's something we definitely need to watch. So I think that's all for what's on in 2017. Obviously, that's not everything that happened. It's been a busy year, but I think they really are the key developments that we've seen. And certainly, please watch this space on the maximum term contracts. It's all very fresh. It just happened last Friday, but there's going to be a lot of talk about that coming out. So that's where we've come from. I think the last question before we get to the questions of our listeners is where we're going. So a bit of crystal ball gazing. A few things about that. There is no doubt that IR is very squarely on the ACTU and Labor Party agenda now. The ACTU has formed a view that the Fair Work Act is not an appropriate form of regulation. Now, this is quite momentous because you've got to remember that the Fair Work Act was drafted by the Labor Party, was drafted with the input of the union movement, but they have gotten to the point that they think that the system is not fair. There's a lot of talk about wage theft. There's a lot of talk about a system being broken. And there is, without doubt, a push on now to overhaul the existing regulatory system by the ACTU. And that will unfold in the scope of 2018. There's going to be a focus on compulsory EA bargaining, we think. So if you can't agree on an EA with your union or with your workforce at the moment, well, no one can force you to agree. The ACTU seems to be looking to push towards compulsory bargaining. Well, sorry, when I say compulsory bargaining, compulsory arbitration. So if you can't resolve your issues, the Fair Work Commission could be able to step in and actually dictate the terms of your agreement to you. That's something that we're hearing and seeing. Equally, there's probably going to be a move to try and limit these terminations of enterprise agreements that we've been seeing become more and more prevalent. That's likely to be on the agenda. The regulation of labour hire and independent contracting is likely to be on the agenda. So, and this is in a couple of spaces. We've heard that the New South Wales Labor government wants to regulate labour hire at the moment. Sorry, not the Labor government, the Labor opposition, I should say, is putting as part of its policy platform the regulation of labour hire. It's just been introduced in Queensland, and so labour hire providers are likely to need to be licensed. More than that, though, there is a focus on what the union movement refers to as sham contracting. And Fiona, I might just get you to explain to us, before we get to sham contracting, I mean, how does one work out? I mean, when we talk about independent contracting, what's the landscape here?
Yeah, so a contractor should be engaged for a specific project. They need to have an ABN. They need to invoice for their services. They usually pay their own super, tax and workers' compensation, provide their own tools and equipment. They can bring someone else in, so a subcontractor of their own, to perform some of the duties. And we get this question a lot, and when we ask the member about the nature of the engagement, we can usually point them in the right direction as to whether or not it's an employee or a contractor arrangement. We also refer members to a number of tests that are available on different websites, such as the ATO, which can help them. There's a checklist available on that website.
Yeah, so I mean, the reality is there's no one test, is there, in the sense that there's a variety of factors that get looked at. And as a principle, you need to balance all of these factors about what's more likely to be an employment type condition versus a contracting type condition, and form an assessment of what whether someone's an employee or contractor. So others are, the degree of control that a principal exerts over the other worker. How much control do they have over how much work they do? How the parties describe the relationship. As you mentioned, Fiona, can the worker delegate the work? All of these things, no one factor is determinative. Yeah. And that's kind of unsatisfactory in a sense, because it's very difficult to advise people as to whether someone's genuinely an employer or contractor. The union movement's saying, well, this is entirely satisfactory because we've got people dressed up as independent contractors who are actually employees. And so they are pushing for deemed employment. That is effectively a process whereby people can be deemed or just identified as employees, whether it be by the Fair Work Commission or someone else. And so we are likely to see more focus in this space, because for as long as the test remains so ambulatory, for want of a better word, or basically so variable, depending on all these different factors, there's going to be confusion. There's going to be people mischaracterizing the relationship. And that fuels the level of cynicism that the union movement has about the way contractors are currently being used. So that's a space to watch. Lastly, increased focus on sexual harassment and the Me Too movement. What kind of things are you seeing in relation to sexual harassment on the advice line?
We hear quite a number of good stories at this time of year. Christmas parties, but really it doesn't need to be a Christmas party. It can be any kind of party. So inappropriate touching, inappropriate comments, quite a number of people who should really keep their phones in their pocket and not start taking inappropriate photos, which are then shared around to a whole number of people.
And look, we do see a bit of that. I think pleasingly there is greater awareness of these issues, and that's why we're seeing more things come forward, which is great. I suppose the issue for employers is how they respond. It's something that needs to be taken very seriously by employers. It's that kind of issue where you do need to investigate. You need to get onto it straight away. You can't have a lazy or laissez-faire approach to these issues when they arise. You need to be thinking about, am I going to investigate internally or externally? And the things you need to think about in that regard are, is an internal investigation still going to be perceived as impartial, as independent? If you've got a separate HR arm, then perhaps, yes, you can do it. If HR involved or it's a really senior executive, maybe you do need to get an external investigator in. And that's something obviously firms such as ours can help with. But from a cultural perspective, it's very important that businesses take these issues seriously and act upon them.
And also set it up before any kind of party so that employees are reminded of what's expected for their behaviour, so that their behaviour at a party is the same as what's expected during normal working hours.
Right, well...
Okay, yeah. Questions?
Yes.
Moving along. So we did have quite a few questions come through. So unfortunately, we won't be able to deal with all of your questions. We'll just have to answer a few of them just due to time constraints. So I was going to ask you, Lewis, we had a question that's what's going to be the biggest risk to an organisation from a people perspective in 2018? Number one risk.
I think in terms of the biggest risk, wow, trying to name one. I might have to name a couple. But I think firstly, this increased focus on inappropriate behaviour at every level, including managerial levels, employers cannot underestimate the need to take these things seriously and respond promptly and appropriately. You need to make sure you have your policies in place for discrimination, harassment, bullying. You need to make sure you have people trained on them. And when something comes up, because it does in businesses from time to time, you act promptly and appropriately. And the businesses that don't do that are the ones that get in all the hot strife. So I think that's one of the huge risks, is not taking these type of claims seriously, because we are seeing more and more of them. I think if I could pick a second type of risk, I think that an ongoing risk is not having appropriate contractual arrangements in place. It's really important. The number of employers who still don't have proper contracts in place that address all the fundamentals that need to be in there, workplace surveillance clauses, clauses that talk about the fact that the rate of pay people get satisfies all award obligations, notice of termination, contracts in place that cover off all the key elements you need. Very important, because when things fall apart and you start to talk about separation, if you don't have the right things in place to begin with, it's a problem.
Yeah, and of course, HR Advance can help with that.
Yes.
So what about, this is about what is the most important factor to consider in developing a strategy to improve culture in a toxic workplace?
Wow. Okay.
But in, a minute.
I think culture is addressed in a number of means. One, it is important you have the right policies in place and training on that. So if you want a culture that provides equal opportunity, if you want a culture that is discrimination, harassment free, you do need to have policies set up on that, and you do need to train people. But more than that, I think you need to have management that will lead by example. And I think we talk about having values-based organisations. You need to actually identify what your core values are, and you need to present that to the workforce, and you need to have your management act in accordance with that. And so it's really led from the front, but it's difficult to do that unless you set up the framework to begin with. So I think have those core documents, have a set of values that your organisation stands by, and then you have to hammer into your managers that it's for them to actually lead from the front.
Okay, I agree. One more, I think. Time for one more. Long-term casuals that don't want to go permanent, are there implications on this for business?
Well, there could be. Look, it's long-term casuals is becoming more and more commonplace. There is a right to elect to convert to permanent status. If they decline that right, there's no obligation to make them permanent. It's a really complicated area, casuals. I mean, whether someone is genuinely casual is going to depend on the industrial instrument that applies. What does the award say about how you can engage people? What does your EA say? If your award and EA is silent, or you don't have an award or an EA applicable, that makes it even more complicated, because we start to look at other factors, which is like, well, what's the expectation of the parties? How regular was it expected the relationship was going to be? What's the legitimate expectation as to whether there's going to be ongoing work? It's a minefield. I think just because someone elects to stay casual, that's not in and of itself fatal. The bigger question is, what do the core documents say? What does the EA say? What does the industrial instrument say?
So it keeps coming back to the documents by the sounds of things. So yes, we will just, I will echo what Lewis has to say on that. Thank you both. I've really enjoyed our chat, mostly chatting by you, Lewis, and thank you. That was really valuable. And from you too, Fiona. It's really great to know what employers' real issues have been this year. So to all our HR Advance community, thank you for listening today and throughout the year. Please feel free to drop us a line at customerservice@hradvance.com.au if you have any follow-up questions, and make sure you log on to HR Advance for practical management of your HR work. At the end of today's presentation, you will receive an email with the video so you can revisit it at any time. I hope you have a happy Christmas and New Year and enjoyable holidays, and I'm looking forward to being in touch with you in 2018. Thank you for listening.